appeal hearing Central Bank of Trinidad and Tobago against Maritime Life Caribbean.
Mr. Benjamin, good morning. I apologise for a delay in the start. It was due to a difficulty I was having with my computer. I'm sorry for that.
Not at all, my lord. We fully understand. My lord, may it please you, I appear on behalf of the appellant, the Central Bank of Trinidad and Tobago, together with Mr. Kerwin Garcia and Dion Springer. The respondent is represented by my learned friends, Mr. Edward Fitzgerald and Mr. Fahad Hossain, who are to my right, together with Mr. Joseph Middleton. I understand attending remotely, I think, I'm not certain, attending remotely are also Ms. Sasha Bijbahansing, Ms. Annette Manchan, and Mr. Adam Hussein. My lord, I thought that I should deal with first my learned friend's note of yesterday. I don't know whether you've seen it. I'm obliged, my lord. My learned friend was kind enough to say to me that the substance of it is to be found in paragraph 4 and 5 of the note. So in essence, I understand him to be saying two things: that no leave of the court is required for the purpose of filing a constitutional motion. That's on the part of his client. And that it follows from that fact, together with the fact that there was, this is paragraph 4 of the note, there was no express order in respect of the constitutional claim against which the central bank can appeal, and that in the absence of such an order, that's paragraph 5, my lords, that I don't have any right of appeal against the continuation of the constitutional proceedings in the High Court. So, my lord, my respectful response to that is, I sought and obtained conditional leave from the Court of Appeal on two bases. The first had to do with the rejection of the Court of Appeal against my challenge to the bringing of the judicial review proceedings, and we'll come to that in some detail very shortly. And secondly, I sought and obtained the refusal of the courts below to dismiss the constitutional claim, because my position set out in the affidavit and also in all of the arguments was simply that no constitutional claim was made out at all.
But did you apply to strike it out?
I did not apply to strike it out.
Well, there isn't, unless you did, then what is the procedure under which it gets dismissed?
Well, my lord, I am entitled to say that there is no viable or sustainable claim for constitutional relief made out against me.
Why are you entitled to say that if you're not applying to dismiss the claim? Or to,
well, my lord,
you can't just come along to court and in the course of some other argument about the judicial review claim, ask for the claim to be struck out, can you?
My lord, that is not what I did. Was separate and apart from the judicial review claim, was challenge the viability and the sustainability of the constitutional motion. And that is made plain, if I can be allowed to invite my lord's attention to it, in our notice of appeal. Can I invite my lord's attention to page 4?
Well, did you appeal to how did it reach the Court of Appeal before it came to
Very same basis, my lord. I challenged it at first instance. I challenged it again before the Court of Appeal. And I sought and I obtained leave from the Court of Appeal. And that the outcome of the obtaining of my leave before the Court of Appeal is set out in my notice of appeal, which you will see at electronic bundle, page 402, which is, of course, my notice of appeal before this board, premise as it is on the leave that I just mentioned. And if within 402, you go to paragraph 20, issues in the appeal, I'm on 20B, my lords. Whether the respondent's case is closed in a violation of its constitutional rights pursuant to section 4B and 4D of the Constitution. And then paragraph 22, I set out the grounds in support of that point. The Court of Appeal erred in law in failing to appreciate the weighing of etc., was not unfair, was not discriminatory, and as such there was no unfairness, no breach of constitutional rights. And similarly, paragraph 30, I set out my grounds.
Well, you can't just create an issue if it never started out as an issue. The only application before the judge was the permission to proceed with the judicial review claim, wasn't it?
That's correct, my Lord.
So it didn't arise as an issue on that.
My Lord, respectfully, it did arise.
Well, just because you came along and argued it.
Yes, my Lord, that's my Lord, I'm sorry. You were saying
Right.
Well, I was just going to suggest to you that appeals are against orders, not against reasons.
my Lord, I accept that.
And you hadn't asked for an order in relation to the constitutional claim to strike
I did.
it out.
My Lord, that's my very point. That I did ask for an order.
So is this right? You didn't issue any form of motion or application.
I filed no application. That is correct.
But in the course of the hearing before the first instance judge.
For the first instance judge, yes, my Lord.
And what order did you ask for?
I asked for the claim against me to be dismissed on the basis that the judicial review was unarguable and the constitutional element was unarguable. In other words, that the evidence in support of the claim for constitutional relief did not disclose any violation at all.
Well, they didn't need to produce evidence in support of that at that stage.
My Lord, yes, my Lord, with due respect, absolutely they did. This is precisely because they do not need leave that in support of their motion for constitutional relief, they were required to adduce evidence. And our rules, Part 56, makes it perfectly plain that you can combine an application for judicial review with an application for constitutional relief. And those were the two elements of the claim. The courts below described it as, or it has been described as either mixed or hybrid. So those are the two limbs, and both of those limbs were challenged. And my challenge was refused. And so my Lord Sales, I accept absolutely that I don't have an order that says your application is refused on both limbs. But that is exactly what I asked for, and I did not get what I wanted, which was the dismissal of the claim. And
have I understood you correctly that
Yes.
you're asking for a dismissal of the claim on the evidence because it could be shown on the basis of affidavit evidence that there was no arguable case?
we say that, yes, we say that there was nothing disclosed at all. We say that there was nothing disclosed at all, that there is no breach. And there could be no breach.
But then, if I may, I go back to the point that Lord Legge was just putting to you, that in relation to the constitutional claim, as I understand it,
yes,
they don't need leave. Therefore, they don't need to present any kind of prima facie case on the evidence. So if you haven't brought a motion claiming that the claim should be struck out, then they're not on notice that they might have to put in potentially additional evidence to meet your application to strike out the constitutional claim.
My Lord, my respectful response to my Lord's sequence of reasoning is as follows, that the requirement of leave applies only in relation to the judicial review, and there is no therefore with respect as far as the constitutional motion is concerned. In other words, we are at one insofar as I'm saying to my Lord, I'm accepting that no leave is required. However, in order to advance a claim for any constitutional relief, you have to do the following three things. You have to identify the constitutional provision that you allege is being breached. You have to adduce evidence that has to cross a threshold of arguability, and you would have to establish, if necessary, that there is no other reason for constitutional relief not to be excluded. For instance, one such reason would be that the legislation that has been passed, or that is applicable or that's in play, has been passed, for instance, with a special majority. So those would be the elements that...
Where do we find those elements? What is the legal source for that proposition?
My Lords, this board's jurisprudence, If I could, it would be any of the cases, Surat, Suraj.
But you seem then to be describing what happens at the merits hearing.
No, Lord, I haven't got there yet. All that I'm saying is that if any one of those elements is missing or is challenged, as was this case, and my lords will see from our written cases that we both engage in a debate on that argument. But I appreciate we don't get there yet.
Sorry,
I'm sorry, my lord.
When you file your constitutional claim, are you saying you have to, as I understand you say, you have to adduce evidence with it, do you?
Oh, absolutely, my lord.
Well, where does that, it'd be helped if you could
Sorry,
say where that requirement is. Is it in the rules of court?
Yes. So, my lord, I don't have Part 56 with me at the moment. Of course, I can get it electronically, but Part 56 requires, in order for a claim to be made pursuant to it, the filing of a fixed claim form together with an affidavit in support, because the evidence, of course, is by way of affidavit. And in this case, that is exactly what was filed. That is to say, a claim was filed in which the respondent sought both of the elements that I've identified. In other words, leave for judicial review together with several paragraphs which sought to establish breaches of sections 4B and 4D of their constitutional rights by virtue of the... I'm sorry, do you mind, my lords? I don't mean to be my learned friend is trying to help me with something. My lord, Lord Hodge, is that all right?
My lord, there's just one thing I think might assist. My lords, if my learned friend would permit, you might well. There is just one thing I think I ought to draw the court's attention to. That's at page 142 of the judgment of Rampersad J. Because the proper respondent to the constitutional proceedings was the Attorney General, and who was the second respondent. And your lordships will see page 142, paragraph 6 of Rampersad J's judgment. He says the second respondent, that's the Attorney General, was represented at the hearing, but chose not to get involved at this time, although counsel did indicate that should leave be granted, that's to say leave for judicial review, an application would be made to strike out the second respondent from the proceedings. That's to say, to strike out the Attorney General as a respondent to the constitutional motion.
But I thought you were relying on constitutional rights against the central bank as well.
We are, my lord. We are.
Right.
But the Attorney General is the natural respondent to any constitutional proceedings. He has to be there, as it were. But my lords, if that doesn't assist, I just...
Well, but it doesn't seem to deal with the constitutional claim against the central bank. That's just the Attorney General saying, well, I might apply to strike out later on. But yes. I think what Mr. Benjamin is saying is that in substance he applied to strike out the constitutional claim against his client, the central bank, at the first instance hearing.
Well, my lord, I'm sorry, that my intervention isn't of any assistance. The simple point we make is that there was no application to strike out. It was treated as if we needed leave, as with the judicial review. We engaged with the process of arguing on the merits, but strictly speaking, our respectful submission to the court would be that in fact the board could not, without there being a motion to strike out as frivolous and vexatious or an abuse, deal with this matter.
Can I find out the application to strike out? Would that be under a specific rule? And if so, what is the test that is set out in that rule? Because you mentioned a test of adducing evidence of a threshold of arguability. And I was wondering whether or not that is, in fact, the test on a strikeout application.
My lord, I would accept that's not the test.
Yeah.
I was simply answering what I thought, with great respect. I thought I was answering a question as to what the procedural requirements were. I was answering a question, and I'm not criticizing at all, my lord. I was answering a question as to what the elements, what was necessary for an applicant to bring a constitutional claim. My lord, Lord Sales did ask me specifically about evidence. I didn't have the sub-rule to mind, but my learned junior, Mr. Garcia, has provided it. That's part 56.7 So Part 56(7)(3) is the rule that provides that there must be evidence. My Lord, Lord Stevens, to go back to my Lord's question, yes. My respectful submission is that the test for to strike out something that is vexatious, there are two elements to it, or two limbs. It's either an abuse of process, or it's really in substance a claim that is utterly unsustainable. We don't rely on the first, we rely on the second. And that's what we said overtly and repeatedly in the affidavit filed by the governor in these proceedings. So our response to the application for leave was to say, you're not entitled to leave, and my Lord knows why we say that, and you don't have anything to say on a constitutional claim. We say it's absolutely devoid of merit, and that's overt and set out in our affidavit.
And what is the procedure then? If you're bringing an application to strike out as an abusive process, do you have to file an affidavit? And do you have to, as a public authority, have to assist the court by disclosing information that would bear on the question as to whether or not there was or wasn't a breach of the constitutional rights of the claimant?
I would say yes to the first question, which is whether we have to file an affidavit, and we did. And secondly, yes, that affidavit ought to make clear and plain, as a matter of common courtesy, upon what basis or bases the respondent wishes to say that no claim can be made out for a breach of constitutional rights against it. And just to support the exchange between my learned friend, Mr. Fitzgerald, and Lord Sales, my Lord Sales, I apologize. The case that is authority for the proposition that you had in mind, which is to say that there can be an allegation of a breach of a constitutional right by a public authority other than the Attorney General. It just slips me, but I will find it in the course of the
I don't think it's controversial because Mr. Fitzgerald is making such a claim.
Yes, my Lord. So, my Lord, to Lord Stevens, I don't know, I hope I've assisted you.
Thank you very much indeed. Thank you.
Well, I can't see, Mr. Benjamin, that your affidavit asks for anything other than dismissal of the application for leave to apply for judicial review. So even if that were treated as some sort of motion, it builds up to paragraph 77 on page 1128. In the premises, I respectfully asking this honourable court to dismiss the application for leave to apply for judicial review.
Well, my Lord, yes, you are right about how it concludes, but not right as to the substance of it. Can I invite your attention to paragraph 66, 1124 of the electronic bundle? So we begin by setting out what we say are the bases.
Well, you can say anything you like in the affidavit, but unless it asks the court to do something, I don't see that you even get off the ground.
Well, my Lord, respectfully, what we say is that the thing that we did ask at paragraph 66, 67, and 69, and 70.
Show me the best, what you particularly rely on there. That is asking for something.
We rely on paragraph 70. In essence, what we say in the affidavit, leading up to paragraph 70, is that nothing in the material in the affidavit sworn to by Mr. Ferguson discloses any breach of any constitutional rights. And we rely, my Lord, of course, this has taken up a little bit more time than I anticipated. My Lord, we rely on how we started, which is to say that we sought and obtained leave from the Court of Appeal, culminating in the notice of appeal and the grounds in relation to our challenge to the viability of the constitutional claim against us that I've already drawn my Lord's attention to. My Lord, Lord Hodge, can I respectfully ask if I can proceed in this way? Unless the board is inclined to rule on this matter now, would you accept my submissions de bene esse? I don't know if that's a course, because...
Well, given the time constraints, I think that is the appropriate course. So we'll take your submissions. And ultimately, your arguments in relation to the constitutional claim will be similar to your arguments in relation to the amenability for judicial review, namely that it is solely a commercial matter.
My Lord, the short answer is yes and no. And can I just give you... Can I say to you now, so that my Lord has it? On the constitutional claim, we say three things. That insofar as the respondent seeks to allege that we have breached or acted contrary to either Section 4B or 4D, they have to explain how or in what manner the central bank, in purporting to exercise its powers under Sections 44D, E, and F of the Central Bank Act, open brackets, the emergency powers of the central bank, close brackets, or close quotation marks, all of which are provided to the central bank pursuant to special legislation, how their claim gets off the ground. And in answer to my Lord Hodge, yes, my Lord, we say that it's not simply that it's a commercial transaction, but that there is nothing disclosed on the evidence, assuming the first point against me, which makes the constitutional claim viable. That's a short way of putting it, my Lord. So, my Lord, my original plan of work this morning was to set out what I thought the issues were, which I think that the board clearly has, and then spend a little bit of time on the nature of the transaction, over and beyond what's set out in the statement of facts and issues, as well as the parties' respective cases. Then to invite my Lord's attention to the arguments on amenability, i.e. that the commercial nature of the transaction. And then finally to close off on what I would describe as the arguability points. And as my Lord Hodges anticipates correctly, respectfully, one can take the judicial review together with the constitutional motion so as to save some time. But in any event, the parties' respective positions is that there is a significant overlap between the nature of those claims. So with my Lord's leave, that's the course I propose to adopt in the time left available.
Well, given that time is passing, I suggest you adopt that course.
I'm obliged, I'm most grateful. Can I therefore invite my Lord's attention, first of all, to page 504 of the record. That should be the invitation that emanated from Oliver Weinman on behalf of...
So could I have the page number again, please?
504, my Lord, I'm sorry. I'm struggling with my electronics.
Thank you.
In fact, can I just ask my Lord just to go back to 502, just for the context? I took you to the body of the document. But, my Lord, 502 onwards, that's the first of the February 2016 documents. And can I just give an overview, and then I would just touch on a couple of points that are set out in the document. As my lords know, this was an invitation to Oliver Wyman, acting as a consultant on behalf of the appellant as well as CLICO and BAT, respectively, to offer for sale the traditional insurance portfolios. Their nature is described in the following page at 504, which is what I had in mind. And my lord, you will see that what the traditional insurance portfolio comprises of. My lord will see it's annuities, group pensions, and individual life policies. And the reason why that's significant is because of the duration of those obligations. Those are long-term obligations that exist for many years into the future. And the reason why that is significant is because it explains the technical approach to the valuation of what those liabilities would look like, and ultimately the nature and shape of the bidding process. Now, my lord, I appreciate that that there's a great deal of commercial sophistication of the board, and what I might be saying is very straightforward and simple, and I apologize for that. Lord, can I invite your attention to 505? So you have under investment highlights, again, a description of what's happening in relation to the books of business. And in essence, my lords will appreciate that both books of business are closed, and what I understand by insurance people to be described as in runoff. The value of the liabilities is to be measured in, obviously, millions of billions of dollars. And what the appellant and CLICO, and the exact wording is replicated in the BAT letter, which we'll come to very shortly, is set out at the very bottom of that page, number 3. So that CLICO and the central bank will be exploring value maximizing offers to both policyholders and other relevant stakeholders, and the financial strength of the bidder will be taken under consideration among other factors in the evaluation of the bids. And that allows me to signal early on, right away, that the consideration that affects or informs the sale of these portfolios is not limited to price. And so we respectfully draw that to the board's attention and say that this is a significant issue in respect of which the courts below, with the exception of Justice of Appeal Raj Kumar, didn't quite fully grasp. Because here, the commercial nature of what is being offered for sale and what is being looked for is in the interest of policyholders and other relevant stakeholders. So that if one thinks about price would be obviously a consideration that's relevant to a shareholder. That's not what was being given first consideration here. And again, just by way of an overt signal, that's reflected in the 6 criteria, evaluation criteria, that are set out in the statement of facts and issues, in respect of which there's no issue between the parties.
Before getting into the detail,
yes, my lords. I wasn't going to.
Just wondering about the test. Do you have to establish that the trial judge and the majority in the Court of Appeal were plainly wrong?
Yes.
And plainly wrong in relation to what is a low threshold for the grant of leave to apply for judicial review?
Yes.
Perhaps a mountain to climb?
Yes.
Yes.
And so, putting on my mountain boots, if I may, my lords, we say that even this superficial entree, this grasp of the nature of what was engaged in, is not to be, just looking at this document, and I'm going to take you to the 2018 document in a second, for the very same thing, just a very quick grasp at a very high level. We say that this approach, this analysis...
I'm sorry for piling the pressure on.
But not, may I just finish the sentence, though, because I might forget. It's not that I don't mind the question. The bowling has been... Well, perhaps I shouldn't talk about cricket, given the way that West Indies is doing. Well, Lord, we say that... That's why I was asking for time. My Lord Stephens, I apologize. Could you just go ahead and ask your question? I'm sure the end of the thought will come back to me.
Mr. Benjamin, your point, I think, was the clear one, that it wasn't just, even at a superficial glance, given that what was being disposed of were long-term insurance policies with long-term liabilities, it was important that the person who acquired these assets had financial strength so that it could cope with the what it was acquiring, and it wasn't just a matter of price. We have that point.
But, my Lord, I was going to say that in a few minutes, but what I was actually going to say in answer to my Lord Stephens, because I did answer his questions, yes, 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 was the next set of answers is no, no, no. But the questions to those answers is as follows. Was this grasped or set out with clarity by the first instance judge? No. Was it grasped or set out with clarity by the majority? The answer is no. Is that an important part of the test? The answer is yes. And we say that this approach is only to be found in the judgment of the minority Justice of Appeal Rajkumar. So, my Lord, I apologize for not getting to where my Lord Hodge is as quickly as you would have liked. My Lord, can I just also invite your attention, apart from 505, I just wanted to show you again very briefly the document that is the 2018 document, and you will see that at page 737. And it is to be found, just for your note, all of this, of course, is set out at paragraph 21 of the Statement of Facts and Issues. So now, my Lords, inviting attention to page 737, you will see that this is one of the two letters that continue the invitation for the acquisition of the tips. And by this time, a couple of things have happened, my Lord. But essentially, because of the nature of those liabilities, their value has been updated, and that's set out on page 737. You will see that in the third paragraph. So that what has happened is that the parties have taken the opportunity, or rather Oliver Wyman and the respective boards have provided up-to-date financials. That material has been relied upon to bring the appraisal up to date. And the significance of all of this is that, of course, it affects the valuation figures, and it affects how the bidders will price and how they will come in. So therefore, there was a connection.
One unknown factor seems to be why there was this lapse of time before this round 3, which then required the figures to be updated.
Well, my Lord, in fact, that's not borne out by what's set out in the Statement of Facts and Issues. And I thank you, my Lord, for asking me that question. Because what had happened was that, and as is set out in the Governor's affidavit, is that there was a significant litigation risk that had emerged that was only ultimately resolved by the winding up of the parent company, CL Financial. And that's set out in the affidavit at, I'll find the paragraph in a second. And when the bidders inquired, they were told overtly that the reason for the pause in the process had to do with issues connected with CLICO. And so, my Lord, there is in fact no mystery as to what happened there.
Well, telling someone that issues connected with CLICO tells them very little. There is a feeling that the central bank have kept their reasoning fairly close to their chest on that point.
Well, my lord, that with respect is how the matter could appear, with great respect, from the distance that you actually and I am now experiencing from Trinidad. But my lord, and this board has dealt with cases involving this very issue before. My lord, the United Policy case arises out of the same circumstance. So, my lord, I simply say that the idea that anybody in the commercial world, with respect, was not fully alive to the myriad of issues surrounding CLICO and CLF, it's not tenable, my lord. This is a once-in-a-generation event. The central bank doesn't intervene in the largest financial institution in the region every Sunday morning. Of course, it doesn't happen like that. The central bank, in order to manage that risk, put a pause while litigation was proceeding. And as I mentioned a moment ago, CL Financial was wound up, and that enabled them, because as I set out at the beginning, the Lords will remember that I said to you that the portfolios are in runoff, which means that the liabilities are changing over time. Of course, they are long-term, but over a long period of time. And therefore, for anything like a fair and transparent process to take place, it would be necessary for up-to-date information to be provided to prospective bidders. And that's why I was drawing your attention to the letter of the 3rd of January 2018. And my lords will see that that was a necessary, we say, a necessary and essential part to the competitive auction process.
Yes, well, as is said in the Statement of Facts and Issues, the reason that the 3 bidders withdrew at stage 2 wasn't the general financial catastrophe that CLICO had suffered, but it was a threatened litigation by the former chairman and principal shareholder.
That's right, my lord. Yes.
Yes, it was a challenge to the resolution plan.
Yes, absolutely, my lord.
Yes, but merely to say, I mean, there were all sorts of issues concerning CLICO, not least concerns of corruption in relation to the Piarco Airport, if I remember right, from other litigation.
Well, Lord, I wish to tread very carefully in respect of that. My Lord is absolutely right, and of course I'm aware that the board has given a judgment. Yes. But I want to be careful about...
Well, I'm not asking you to make submissions on that. What I'm saying, merely to say to a bidder that there are issues relating to CLICO when there were multiple issues relating to CLICO is not exactly an explanation as to why, where a valid bid had been put in at the second round, that was departed from. But anyway, please make your submissions.
I'm obliged, my lord. My lord, my lord, you have got it on page 1113 at the very paragraphs that you that I was going to invite my lord's attention to, but my lord got there before me. That this litigation, and so my simple point was this, my lord, that this litigation was notorious, and that this litigation, the litigation referred to at paragraph 21, that is what directly affected the process for the sale of the tips, as opposed to, my lord, the general proposition. I am not relying upon the general state of affairs. I am relying on the fact that all of this, and this in particular, what's set out at paragraph 21, would have been notorious. That was my simple point, my lord. It's not in substitution for what my lord has correctly drawn to my attention. My lord, I was about to just take my lord's two other aspects, or 2 or 3 other aspects of the competitive auction procedure that's set out at 737, 738, and 739. Sorry, my lord says that...
No, sorry.
No, my lord, I didn't hear it. I thought you were going to ask me a question. So my lords will see that 737 is a competitive auction procedure, and that what the parties are invited to do is as follows. They are invited to look at the updated appraisal material, that's on 737. They're invited to continue their participation in round 3 of the binding offer. And if you go over the page to 738, you will see what the 3 steps were. In particular, I draw your attention to step number 3. They're invited to review the draft seller's agreement for the transaction and submit that with their binding offers, which reflects the most competitive position that they would be prepared to offer. And you will see the very same point is repeated over the page on 739 under the heading 1.3. Does my lord have it? 739? And then, my lords, over the page on 740, my lords will see that certain terms are set out as to what's required in a binding offer. And just by way of, just to add to the draft seller's agreement, I invite my lord's attention to the fact that the bid prices would be affected by what's set out at 7, which is the methodology to roll forward to the date of the purported transaction. It will also be affected by any changes in the interest rate. And my lords will see that at number 10, there is a specific requirement that the offers must not be subject to any condition other than the mandatory approvals and authorizations.
If I understood correctly, this letter is just relating to the Clico portfolio.
My lord, you are right, but there is an identical letter for that.
Right.
Yes? And my lord, I'm proposing just to show you that very quickly because the language is absolutely identical. And then, my lords, finally, on relation to the nature of the commercial nature of the transaction, can I just ask you to look very quickly at pages 742 and 743? And I have just a couple of points to make there. My lords will see that there is a requirement of confidentiality. And then can I take you to the 3rd paragraph? And I suspect that this kind of language would be standard. And my lords will be very familiar with language of this type. My lord, in the 3rd paragraph, starting with the words "in addition," is my lord Hodge with me? On 742. It's like the 5th line in the 3rd paragraph. In addition, you will not be entitled to claim any form of any form of exclusivity with respect to the transaction on the basis of this letter, and the seller is not obliged to enter into any exclusive negotiations unless and until such may have been explicitly and expressly agreed upon by means of a written contract duly signed on behalf of the seller. That's 1. So no exclusivity in terms of negotiation. 2, the seller reserves the right to reject any or all binding offers without discussing the reasons for any such decision. And then 3, the seller shall not be obliged to review nor to accept the highest or any offer. So again, standard language. And then finally, just for the avoidance of doubt, under no circumstances is this is to be deemed as a contract, etc., etc. And that's on page 742. Can I just take you to 743? This is the 2nd paragraph on that page. That you understand that neither the seller nor its advisors will be required to comment upon any proposal, or you accept that under no circumstances there will be any requirement to draw your attention to any possible mistakes, misinterpretations, or miscalculations on your part. And of course, the letter is subject to the laws of Trinidad and Tobago. And my Lord says, in answer to my Lord's sort of implied question, for your note, it's 746. You will find the bad letter.
Before moving away from 742,
yes,
and the right to reject any or all binding offers,
yes,
that must be subject to the public law duty, not to, for instance, to discriminate. You couldn't reject it on the basis of race or some concept like that.
Absolutely right, my Lord. Yeah. And that's precisely what is said in the affidavit, or what is signalled in the affidavit, and precisely what is signalled in the submissions. Yeah. To anticipate my Lord's question, precisely what was set out in the submissions, both before the first instance judge and the Court of Appeal. So, my Lord Stevens, just to pick up on what my Lord observed a moment ago, and therefore, because we are subject to the Constitution like everybody else. If you want to make a complaint of constitutional breach or violation, you've got to ground it in the way that my Lord Stevens just identified.
So
and that's the complaint, our complaint. Our complaint is that it was not so grounded.
I was just looking to see what the public law standards are that apply. There's one that you've just referred to, that's
yes.
equality of treatment.
Yes.
The other one would be fair and equal treatment.
Yes.
The other would be accountability and transparency.
Yeah. Well, my respectful submission is that the third would be covered by the first two, but my Lord, I don't have an issue with what you're saying.
And the next would be good faith, and the next would be rationality.
My Lord,
all those would apply.
Absolutely, that's accepted by us, and what we say, well, my Lord already has my submission on it, that nothing of that sort was set out or made out, even on a prima facie basis against us. That's really our answer in relation to the constitutional claim.
But in relation to amenability, these contractual terms,
yes,
they are still subject to those public law duties, and those public law duties are amenable by way of judicial review.
My Lord, you have to show that to overcome, as it were, the issue of amenability, so to speak, on the basis of a commercial transaction, unless my Lord's decision in State of Mauritius, which itself reaffirmed the position in Mercury, which simply says, you are subject to these public law duties as follows. Ordinarily, commercial transactions are not amenable to judicial review in the absence of bad faith, corruption, and I think it's dishonesty. Fraud, sorry.
I think you have to be a little bit careful.
But Lord, I'm so sorry.
What you take from the State of Mauritius, because in fact, in the judgment in that case,
yes,
it was affirmed that public law duties would apply.
Yes.
And then there would be question marks as to what public law duties. And in fact, it was accepted that, for instance, a legitimate expectation might arise.
Yes.
It was found not to have done so or not to have been breached in that case.
Yes.
So it's not a case that you can only succeed on a public law claim if you can show dishonesty or something like that. It depends what public law duty one is looking at.
My Lord, can I say that I accept that correction of my far too energetic summary of what my Lord decided in the
Can I ask you this? Because in answer to my Lord Stevens, you've been focusing on the constitutional rights, but the public law obligations of the central bank aren't limited just to compliance with the Constitution.
I accept that, my Lord.
Public law obligations of their own arising under their statute and under general principles of public law.
My Lord, I accept that. I hope that my answers to my Lord Stevens were not to be taken as being limited to the constitutional question. And so, my Lord, in my lack of clarity, I apologize for that, my Lord Stevens. My Lord put to me a series of propositions on the public law bases, and my Lord, I have, my Lord Stevens and my Lord Sales, I have no quarrel with any of them.
But it's also the power, the statutory power, is to be exercised in the public interest.
My Lord, absolutely. And my Lord, so it's helpful to close off on, as my Lord invited me to do a moment ago, and to make the following submission in relation to the public interest, that the purpose of the sale, as I was to further the public interest and to protect the rights and interest of these existing long-term policyholders by ensuring a sale to a strong, well-capitalized, my Lord has got the phrase, value maximizing by way of a value maximizing offer to the prospective bidders. And my Lord, respectfully, our respectful submission is not just that was what was done in this case, but that there is no arguable case on either basis that the procedure that was adopted by the central bank by way of process and outcome is incidental in a sense. By way of process and outcome, there's no arguable case that that objective was not sought and advanced by everything that the central bank did over the course of the period of time between 2014 to 2018, when the decision was taken to approve the decisions of the board to select a preferred bidder. Can I just invite my Lord's attention? I just wanted to close off, my Lord, on the level of detail, and just to make one point as to the nature of the transaction. And can I just invite my Lord's attention to page 805 of the electronic bundle. My Lords will see that is the letter addressed to the respondent from Oliver Weinman. And I'm really on just closing off on the nature of the transaction. And simply to say, as long as my Lords have it, simply to say that what happened in this case, as my Lords know, is that the preferred bidder was written to, the respondent was written to on the same date. That's common ground. And of course, here's what it says. Over the next 6 weeks, there'll be further negotiation with the selected preferred bidder. And should these negotiations not be successful, we may revert to your offer and recommence negotiations with you. Please confirm that your last bid will remain valid for at least 6 weeks. So that what was anticipated is that with either one party or with the other party, that there will be further negotiations in relation to the ultimate bid price and other terms and conditions set out in the draft seller's agreement as a means of closing off the transaction. And so that occurred as early as September 2018.
Can I just check one thing on the letters relating to each of the CLICO and the BAT portfolios?
Yes, my Lord.
When we looked at condition or clause 10,
yes,
and we see it in the BAT document at page 749, and as you said, it exactly replicates the CLICO one.
Yes.
Am I right in thinking that both these letters were inviting separate bids for the CLICO portfolio and the BAT portfolio, each of them to be non-conditional in accordance with clause 10?
Yes.
All right, thank you.
Yes. But, my Lords, can I just take the opportunity to say that, as my Lords are aware, in this case, the preferred bidder said, and this is just my paraphrase, I am not interested in BAT if I don't get CLICO, but if I do get CLICO, this is my offer. And so what I say about that right away, my Lords, so that my Lords have it, is that that is the response of astute, fair-minded, reasonably well-informed bidder.
Well, it sounds like a condition. I mean, seriously.
My Lord, I know.
You're going to say it's not a condition.
My Lord, we say respectfully, it's not a condition in the sense that it's being used in this document. So that's the difference between us. We say it's not a condition in the sense it's being used in this document. We say that all that it is one bidder saying, I am interested in both portfolios. I have a greater desire to acquire one or the other, and this is how I'm prepared to do it. And we say that that response, as it happens, is A, consistent with the bid requirements, B, consistent with and in furtherance of the public interest, and C, not in breach of our acceptance of it is not in breach of any of our public law duties whether under the Constitution or at common law, because of course, as my lords know, we have our judicial review procedures on a statutory footing. My lord, yes.
Clearly you have arguments you can make in that regard as to the proper construction of the condition in the letter inviting bids. But the hearing that the court was concerned with was a leave to appeal hearing, not a rolled up hearing.
Indeed, my lord.
And would it not be the appropriate place for the determination of such matters to be at the hearing on the merits of the judicial review?
Ordinarily, yes. Save and except that in this particular case, unless I've misread or I'm misreading the authorities, in which I think my lord had a rule. But Lord, I really have the home care. I'll get the correct citation in a moment. It's in the Joint Bundle of Authorities. That what I understood the Supreme Court to have said in the person of Lord Reed, approving my lord's decision, sitting as the Lord Ordinary, was that the construction of this particular clause, of course I'm applying the reasoning to this particular clause, the construction of this particular clause is as follows. A, it's a matter of construction. It is not the same as, but it may be analogous to the ordinary rules of contractual construction that this court is very familiar with, and therefore I will not cite any authority in support of that. And that therefore is an issue which, in accordance with the board's jurisprudence, starting with my Lord Sales's judgment in Caesar, but following in other cases where I believe my Lord Stevens, I think it is in the Sukan case, followed, where insofar as the court can be invited to decide an issue like this, i.e. an issue that doesn't admit of evidence, it's not a question of the subjective interpretations of the parties, it's a pure construction issue, whether or not that is the sort of question, we say with respect, that ought properly to be decided by the court on an application either for leave for judicial review or on an application that seeks to say or challenge a constitutional motion as not having any basis in law or fact. We say that, and it's a limited class of cases, we say that this one falls into that limited and small class of cases whereby the court can properly be invited. And we go further to say that not only is that a proper invitation to the court, that we say respectfully that what really happened in the Court of Appeal by way of the majority as opposed to the minority was, pardon the euphemism, kicking the can down the road.
But when we're looking at an application for leave to move for judicial review, very often, I would say in about 90% of cases, it turns on proper interpretation of a statutory provision.
Yes.
The court doesn't move, following your argument, to say, well, we can construe the statutory provision now, let's do it. They look to see whether there is an arguable case for a particular interpretation of the statutory provision, and if there is, one moves on to the merits stage. So why wouldn't one reason precisely the same in relation to interpretation of these letters?
My Lord, respectfully, in 90% of cases, that is an absolutely perfectly appropriate course to take. My Lord, so my respectful submission, and I'm not going to try to restate this, I'm just going to say it once. My Lord, in some cases, and this is one such case, the issue is sufficiently narrow and discrete and limited because, as my Lord appreciates, with respect, this is not a question of the construction of a statute. It's a question of construing one line or one particular condition in a broader context in a few-page document.
Do we have the offers that were made that are said to be conditional or the dispute is about? Do we have the framing of the offers made by the successful bidder?
My Lord, I think it's to be found in the board note. I can
give
say
you the
to
reference later.
Yes. Well, my lord, can I do it now? Just because I might run out of time. My lords, subject to what my juniors tell me, my recollection is that is to be found. It's set out in Mr. Ferguson's affidavit. It's paragraphs.
1079 EB.
Yes, paragraph 69 to 76. And the supporting document is, I think my little friend did see it. Right. No, Mr. Just bear with me. You are correct. It is 1075 and following.
So this is the document you say actually should not be referred to. Is that right?
No, my lords.
Is this not the confidential?
Well, it is confidential. We say as a body that was engaged in or supervising a commercial transaction process where the parties signed up to confidentiality, that as soon as this document came to their attention, they should have handed it over. But, my lords, I'm not on that. I don't make a point of that for the purpose of my appeal.
No, but in the proceedings.
Oh yes, my lord,
as a whole, you do.
Yes, and the court.
And is it not
ruled against me? So that's why.
Is it not correct that in the central bank's affidavit they don't go into this detail? They don't, for instance, exhibit the offers that were in fact made.
That's correct, and that's because this document was there. That's the point. In other words, if you strip away what Mr. Ferguson says is, well, this is the document that I found, and these are the offers, and so on. All of Mr. Ferguson's documents are my documents. That's my simple point. And I'm not sure. My lord hasn't asked me this, but I want to make it plain. We do not and did not challenge the authenticity of the document. Our concern was, as my lord already anticipated, a minor one in relation to the use of a confidential document. So, my lord, to answer my Lord Legate's question, you will see the offer to be found on page 1078. I trust my lord has it.
Yes, it doesn't really explain there how the bid price will be improved by 73 million. I mean, there might be different ways of achieving that.
Well, my lords, again, I wasn't proposing to get into too much detail. As my lord must appreciate, I'm sure by now, that in essence what is happening in this instance is that the bidder identifies the value of the assets that he or she or it requires to assume the liabilities. Mm-hmm. So that in the competition between bidders, and I'll just leave the facts to one side and just use a very simple analogy. If one assumes that the liabilities are a value of 10, and it doesn't matter what 10 is, 10 billion, 10 million, pounds, dollars, doesn't matter, then what a bidder is doing is saying, well, give me 8 or 9 or 7 worth of assets to meet those liabilities. So that's number one. And therefore it means that no cash changes hands. That's number two. And number three, it means that to the extent that there is, in relation to CLECO, a shortfall, but in relation to BAT, as my lord I'm sure sees on page 1077, there is no shortfall. In other words, what both bidders were asking for was for assets in excess of the liabilities. I trust my Lord Hood sees that. So that, sorry, I said both bidders. I should actually clarify that. All three bidders for BAT were asking for assets in excess of the liabilities. So it necessarily follows from that any one of these transactions, or all of these transactions, would adduce to a loss on the part of the entity or the shareholders. Is my lords with me? Well, I hope I've gotten it right, because I'm sure that if I did not get it right, my lords would correct me. and so, my lords, to answer, although my Lord Sales didn't put it like this, implied in the question that my lord asked me is really whether it's permissible, or was it permissible, for a combination of the two bids. Because my lord asked the question, weren't they being sold separately? And that's absolutely right. From 2016 to 2018, these two were being sold separately but in parallel. And their desirability and their impact were different. Their scale was different. But 560 million, the figures are all here, 500 plus million, Clico billions by comparison. In 2016 it was 9 billion, in 2018 it's 8 billion. So one is huge and significant systemically, one is much smaller. The requirement of the strength of your balance sheet for the first Clico, much bigger than, of course, the second. And that is obvious from what's set out at the very top of page 1077, where the respective balance sheets of the parties are identified. In other words, the parties that are bidding for both. And you will see that Sagicor is... I'm sorry, my lord.
I do apologise, but
not at all,
what was Sagicor's bid for BAT, initial bid, and how did it change then if they got Clico? Where do we find the answer to that?
My lord, I'm sorry, I thought I'd answered the question.
Well, I don't see where the documents are that explain it, and I may have missed something. And I wasn't certain whether you were explaining it as a theory as opposed to what actually happened.
No, my lord. So what I was saying was, it was a very simple analogy of explaining what actually happened and what was anticipated by this process. So my lord...
The structure, what it's indicating is that Sagicor made a bid for that, which said this bid is conditional on your accepting our bid for Clico. It otherwise won't be binding. It's only a binding on us if you also accept our Clico offer. Is that right?
My lord, that's a fair way of putting it. In essence, they were saying that if we don't get Clico, we're not interested in BAT.
Well, that's what it says here. So I'm translating that into more legal speak, which is that this offer I'm making for BAT is binding only if you conditionally on your accepting our Clico offer, otherwise not binding.
So, my lord, I was going to show you the offer for...
And just to take on Lord Leggett's point,
yes,
in some way the offer for BAT would become binding if Clico was offered, and in addition you get an extra 73 million.
Yes, my lord.
In relation to BAT or in relation to Clico?
In relation to both, my lord. That's what paragraph 2 says.
Which paragraph?
Sorry, on 1078, this is necessary because, but I appreciate my Lord Leggett is taking me to task for non-legal language, but I just wanted to rely on the evidence.
The 73 million must be for BAT, surely, because this is a BAT document.
Lord, with respect, that's not what it says, though, my lord.
Well, it says, but this document is BAT's evaluation of bids for BAT.
My lord, I accept all of that. All I'm on with respect is what it says. Well, Lord, I have to be careful about what I can say to the board. I can't give any evidence. But, so, my lord, what is said here represents the position.
And that is that there's another $73 million being offered for BAT if they get Sagicor.
Well, my lord, that's not what it says, though, with respect. My lord, I'm happy to be corrected.
It says, because BAT aren't assessing the Clico bid, BAT are assessing the BAT bid. And in order for the BAT bid for Sagicor to replace Maritime in the separate BAT bid, Sagicor has to offer more. What does it offer more? Its bid price goes up by 73 million. I mean, isn't that what the document says? Whether that's right or not, I don't know. Just reading the document, isn't what is being done is assessing what is the bid for BAT.
Well, my Lord, because I hesitate to have any difference of opinion with my Lord.
But just look at page 1078.
Yes, my Lord. So my Lord, can I just... My Lord, I'm very wary.
You interpret it as a single bid, do you, for both companies? That's 73 more without allocation?
Yes, my Lord.
How do you interpret it?
Yes, my Lord. That is why I took you to the letters which talk about negotiation. In other words, this document is clear evidence that the allocation hasn't taken place yet. That's the only point I'm on. I can't give any evidence as to what the allocation is, but the allocation has not taken place yet. That's the only point.
Isn't the difficulty that you face that none of this has been explained by the bank? They haven't actually condescended to any details in relation to it. All they've done is they tried for the courts to construe a document that was made available clandestinely, if I may use that word. The bank themselves haven't actually explained the position, and yet the bank are coming along and saying that they acted fairly.
Well, my Lord, we took the view that the documents speak for themselves, perhaps wrongly. We took the view that what we were required to do was to ensure that the court had the accurate position. We took the view that once we affirmed the authenticity and reliability of the documents, and once we set out what our process and our procedure and our approach was, which was to identify, in accordance with the documents, how the criteria were applied, which is what we set out at paragraphs 67 to the end of Dr. Hilaire's affidavit, that was what was required to explain, with respect to Lord Stevens, how we arrived at our position of approving the decisions that this document represents. So this
if your interpretation is correct of
yes.
the document on page 1078,
yes.
then it looks as though the bid didn't comply with the requirement to make separate offers for each company. You're saying that it was a price that was a global price, which couldn't be broken down without further negotiation into what part was referable exactly to BAT and what part to CLICO. That's what you're telling me, I think. The 73 million wasn't allocated between CLICO and BAT in the bids, so they weren't separate for the two. They weren't separate for each company.
My Lord, our respectful submission on this is straightforward, which is that when you look at the contents of the board note and you look at the values that were being offered for BAT, that it was desirable and in the public interest, and we say respectfully, consistent with the bid documents taken together, for a bidder to say, I am interested in both portfolios, and that can be done by one of some Lord. I'm just waiting. No, I didn't. And that we say respectfully that can be done one of three ways. In other words, a bidder can say, I am interested in CLICO only. Or a bidder can say, I am interested in BAT only, as NCBJ did. Or a bidder can say, I am interested in CLICO and I'm interested in BAT. And thirdly, we say, a bidder can say, I'm interested in CLICO together with BAT, but I'm not interested in BAT if I don't get CLICO. So we say that there was nothing in the bid criteria, nothing in the language that excludes either expressly or by implication such an approach.
Okay.
Well, I must say, I really struggle to see how we can read the document that you've been referring us to as having the meaning that you're attributing to it, that somehow the 73 million was a composite sum which could be split between BAT and CLICO.
My Lord, yes, my Lord, with respect, I have to tell you, my Lord, that I did read the document literally. I am sort of, burdened with instructions and therefore taken aback by how my Lord reads it. But I certainly see...
But just stand back for a second.
Yes, my Lord, I am.
That board, if we start at the front of the document...
Yes.
They say it's a proposal for the selection of a preferred bidder for the TIP.
Yes.
TIP are they talking about?
They're talking about that.
TIP. Look at 1.0, paragraph D. We're talking about BAT's TIP. We're then told there are 6 criteria for the evaluation of bids. The one which is given the greatest weight is achieving a competitive fair transfer price that balances CBTT and policyholder interests. Although I think it was asserted somewhere in the central bank's case that there was another criterion which was weighted higher than the price criterion. And then we're told that certain bids were received. That's bids for BAT's TAP. And then we have a discussion of the rationale for the ratings of the various criteria, and when we get to achieving a competitive fair transfer price, we're still presumably talking about a bid for BAT's TIP. We have certain figures, and then we have the evaluation, and that we're told that Sagicor's bid price is improved by 73 million if both portfolios go to Sagicor, and that results in the evaluation of the bids for the BAT TIP to alter between standalone and the circumstance where the CLICO goes to Sagicor. I mean, how someone reading this document is meant to interpret it as indicating that the 73 million is a composite sum split between CLICO and BAT, I don't begin to understand.
Well, my Lord...
And it might suggest that there has been a distinct lack of transparency.
Well, my Lord...
part of the in this process.
My Lord, we would respectfully submit, and we'd invite the board not to come to any adverse conclusion against the central bank that has, over a very long period of time and at great expense, with only the public interest involved, engage in a process for the sale of TIPS portfolios, which required them to retain international competence and expertise for the purpose of designing and facilitating this process.
Well, I mean, you've got big points there. I mean, clearly the central bank involved Oliver Wyman. Oliver Wyman were intimately involved in carrying out the process. You have that point clearly made.
Yeah, yes, my Lord.
But what I'm very puzzled by is why you're telling me, reading this document, which is the BAT board assessing bids for their TAP, alter their evaluation to favour Sagicor over Maritime, when you're saying that the bid price, the increased bid price of 73 million may not be attributable only to BAT.
Well, Lord, again, I've said it twice.
You say those are your instructions?
No, my Lord, it's not simply my instructions, my Lord. Lord, yes, those are my instructions, but, my Lord, that appears to be what the document says.
If you look at 1081.
1081, my Lord. Yes, I got it, 1081.
Heading achieve competitive fair transfer price.
Sorry, my Lord.
Second bullet point. Sagicor was a conditionally higher offer for BAT if CLICO goes with Sagicor.
So, my Lord, could you just repeat the reference, my Lord? 1081.
Achieve competitive fair transfer price.
Yes. Sagicor has conditionally higher offer for BAT if CLICO goes to Sagicor.
Yeah.
And Sagicor may reduce assets by an additional 73. My Lord, I entirely accept that reading that line it doesn't have the complication or the ambiguity of both, which is on the other page. And reading that line, my Lord, I would find it very difficult to have any quarrel with how Lord Hodge is reading it.
But you're telling me that that in fact is wrong. You're making representation that...
Well, my Lord, I'm trying to be careful about what it is I can say. My Lord, my understanding was that page 1078 had been read as though it applied to both, but I certainly accept that 1081 does not support that.
Well, I can see I found some support for your point on what is 1083 or 1084. It says there's an asterisk there. It assumes that 73 million premium is allocated on an equitable basis between BAT and CLICO.
Yes.
With BAT receiving a minimum allocation of 30 million.
Yes. And so, my Lord, as usual, knows the papers better than me. My Lord, I'm sorry. So, my Lord, and can I just connect it to 1077? So the importance of it. So, my Lord Hodge, can I just tell you what I'm addressing now? I'm addressing the idea that there was a lack of transparency, and all that I'm saying is that based on the bid prices for BAT, the BAT portfolio was a less than desirable portfolio, because otherwise sophisticated commercial bidders would never say, give me more assets than the liabilities are worth, which of course is the opposite in relation to CLICO. So that relatively speaking, and in that context, my lords, the 73 million, I'm very grateful, 1084, 1081, 1077, 1078. My Lord, the following is my respectful submission. A, it makes commercial sense. And so insofar as my learned friend at Section 4 of his written case seeks to tackle the commercial viability of the TIPS transaction and takes issue with it, we say respectfully that this document and the context in which it is set out. So A, it makes commercial sense. Well, what does commercial sense mean to the seller? Given the control over the entity, what commercial sense means is, well, where is the best and safest home for the policyholders? That is also consistent with the 6 criteria. So, my Lord Hodge, you are absolutely right. In relation to BAT, price is ranked as high as financial stability, if I could call it that, or the strength of the balance sheet. So that is the way that, especially those 2 criteria, but no, they aren't the only one, but especially those 2 criteria.
Price is ranked highest for BAT, but you say there was a different ranking for CLICO.
It was a different ranking for CLICO, but I'll come to CLICO in a second, my lords, because I just want to close off on this document and just advance our submissions, because, my lord, it's very, very, very important. Just in terms of, my lords, when the board speaks, it has impact. So that even on an interlocutory judgment, so what is being contemplated here by the central bank in the execution, in the retention of these individual consultants and so on, was really intended to balance a return, but really giving equal prominence in relation to BAT, to safety, and by contrast, as far as CLICO was concerned, and this is set out in the governor's affidavit, giving prominence to stability and safety.
So, but when you say equal concern for BAT, why do you say that when the ranking on page 1082 appears to rate competitive fair transfer price as having the highest weight?
My lord, yes, I'm not running away from that. I'm relying on that. I'm saying that the highest weight given to price is one of the 6 criteria. That's where I'm going. That's really the point I was making. My Lord, so I'm trying to make a point as to, well, what does commercial decision-making entail in this case? And in this case, so my point to my Lord, in agreement, my Lord, Lord Hodge, to your observation, was that in relation to BAT, price is important, but of course it's not the only criteria.
No.
That's really my point in relation to BAT.
Well, that's abundantly clear. I mean,
yes.
it's one of 6 criteria, and clearly it can be outweighed by others.
Yes, and one does not need to go there for the purpose of this conversation. I want to contrast that to the position in relation to CLICO. So in CLICO's case, what makes commercial sense is ensuring that policyholders are safe and that there is no repetition, no risk of repetition of balance sheet inadequacy should there be over a long period of time.
What do you say about the point that, that's just a commercial point, but that Sagicor had to set up a subsidiary which would be the actual holder of the assets, and there was no information about whether that would be financially strong. I mean, the fact that you have a financially strong shareholder is not maybe neither here nor there.
Well, my Lord, with respect, it's the opposite is true. In fact, the central bank experience in this case with CLICO was precisely what my Lord, the opposite of what my Lord just identified. That when CLICO as a subsidiary got into trouble, and when BAT as a subsidiary got into trouble, the parent company simply didn't have the resources to do anything at all. It could not do anything, and that's hence the reason for the January 2009 Memorandum of Understanding. And so, my Lord, we say, Lord, with respect, there was nothing in the point. That's my respectful answer. Can I, if my Lord...
That depends whether you've got guarantees from the shareholders, doesn't it? Or whether they are going to stand.
Absolutely, my Lord. Absolutely, my Lord. And that is all the process. So one does, in transactions of this nature, one does an initial level of due diligence. You provide me with your books. You tell me what you're doing. And if I am not satisfied with what you actually do in relation to the level or the strength of the balance sheet of the domestic entity, well, then, of course, you can't, the scheme of transfer can't go through.
Okay.
And this...
You say that would be part of the detailed negotiation?
3 things. It's part of the detailed negotiation, covered in the draft sellers agreement, and 3, expressly contemplated by the scheme of transfer. That's the whole purpose of it. The whole purpose of the scheme of transfer and the whole purpose of a hearing under the Insurance Act of 2018, and my Lord, just bear in mind that at the time when these transactions were being undertaken, that act was not yet enforced. So that what the central bank did, and my Lord Hodge, I'm on transparency now, was say you must comply with the Insurance Act of 2018 as though it is enforced, because that is better for policyholders. That allows us to look after, to do as best we can, because my Lord, Lord Leggett, even with guarantees and warranties, there is no certainty. That's the fundamental point. And my lords are very well aware that at the end of the day, as far as financial institutions are concerned, because there have been collapses all over the world, what is required is a strong balance sheet. That's effectively what Basel is about. My Lord, Lord Stevens.
Well,
I'm aware I only have half an hour left, but no, sorry.
I do apologize. You say that this was a decision primarily based upon the financial stability of Sagicor. But at present, I don't see where the comparative exercise is being carried out as to the financial stability of Sagicor and of Sagicor's subsidiary and of Maritime. That's part of the complaint made by Maritime, that is, that they were still envisaged to be a satisfactory bidder because the letter to them said, hold on, don't go away.
Yes.
And yet they say there has been no comparative exercise carried out as to the financial stability of these 2 companies.
And my Lord, what we say is that that process, as indicated in the board note, had begun but was not yet complete. And in effect, my Lord, there's no value in me repeating everything I just said in answer to my Lord Legate. Okay. But that's a process.
But how do you make a decision
yes.
in the public interest to go for Sagicor when you'd started a process but hadn't completed it?
Well, Lord, with respect, we've made a decision about the preferred bidder. And that decision is a decision to negotiate with that preferred bidder and to go back to my Lord Legate's, if I may say so, very prescient question, to ensure that the terms and conditions that we want remain as part of the draft sellers agreement. So, my Lord, it's not true to say that that process isn't underway. It is part of the bid process. And that's why I was very careful, I hope I was careful, to take you to that element as one of the conditions, because it's not simply a question of identifying what the commercial structure or nature of the transaction is. It's also about, well, what were the mechanisms? Because there is what are the mechanisms put in place as part of that commercial process to protect policyholders? That's really what this case is about.
But I mean, you seemed in your answer to be saying that looking at the financial stability of Sagicor or its subsidiary would be part of due diligence.
Yes.
But why shouldn't it be part of choosing the preferred bidder?
Oh, my Lord, I'm so sorry. I didn't mean to suggest that it was one and not the other. Right. In fact, my answer just now was intended to say...
in that case, I think I'm repeating Lord Stevens'
My Lord, yes. My Lord Stevens.
There doesn't seem to be any indication in the limited documentation we've got
yes.
of a comparative exercise between the financial stability of Maritime as against yes. Sagicor and or its subsidiary. Can you help us with that?
Yeah. My Lord, my first answer is the assistance that I can give you is to be found in the affidavit of the governor, and the answer to my Lord's question is that it was part of the bid process, but it did not stop at the bid process. That's the answer that I gave to my Lord Legate.
Could you refer us to the particular paragraph
yes,
of the affidavit on which you rely?
Lord, it really starts on page 54. 55 sets out the criteria. I'm on page 1121 of the electronic bundle. Paragraph 54, paragraph 58, paragraph 59, paragraph 60, paragraph 61,
that doesn't
paragraph 67. Sorry,
just to
yes.
That doesn't seem to be setting out any kind of comparative exercise, or am I missing something?
No, my Lord. Paragraph 68.
Well, 60, you might say, it was Sagicor was selected as the preferred bidder based on its relative size, experience, financial strength, etc., etc.
Yes, my Lord. So 60, 61, and then 67 and 68 in particular really focuses on Sagicor. So 68 is Sagicor, is the Sagicor process. And my Lord, unless my Lord, we have misread Lord Reed in Health Home Care, what is required, sorry, that's Health Care Home Limited. That's at TAP. My Lord, I apologize. I sometimes forget who gives the judgments in these matters.
I'm familiar with the decision, yes.
But my Lord, fundamentally, unless the board is prepared to depart from what is said by the Supreme Court in that case, what is required from us is a summary reasons. We don't even have to disclose the evaluation documents according to Lord Reed in that decision. So that in this case where the evaluation documents are available, and again, I'm not frivolous how they got them. They have them. They have our documents. They have the confidential documents. The process was compromised in that respect, but that's not the point. The point is that they already know. And insofar as they wish to complain about the responses, we say as follows. we say that they were told explicitly in the central bank's quarterly reports. Those are annexed to the affidavit of the governor. These are the ones that are sent to Parliament and to the Registrar of the High Court on a quarterly basis. They were told that Sagicor had been chosen. They were told that in September of 2018. They were told that negotiations were underway in relation to the very same draft sellers agreement that I was debating with Lord Stevens and Lord Leggett a moment ago. They were told that, and that good progress had been made in December of 2018. So, my Lord, with great respect, my Lord Hodge, insofar as there could be a complaint about a lack of transparency, it's very, very difficult, very taxing to identify what's the basis. Because none of these things, none of those matters form the subject of any complaint by the respondent. And then on top of that, in addition to what is set out in the affidavit of Dr. Hilaire, there is a comprehensive, at least we thought it was comprehensive, response to the pre-action letter. And that is, I'll just get that for you. It's Electronic Bundle 917, that's AF41.
This is 917.
917.
Thank you.
And so, my Lord, what we say about this letter, because I'm very conscious of the time, I've got 20 minutes left. What we say about this letter is that it's healthcare and home limited compliant. In fact, we go further. We say with the greatest of respect, it exceeds the criteria or the requirements set out by the Supreme Court in that decision. And we say that to that extent, any complaint made by the respondent about reasons, any complaint made about a lack of transparency, any complaint made about my Lord Stevens in relation to bad faith, all of those matters go by the board. And if you go to Mr. Ferguson's affidavit, you will see that there is not a scintilla of complaint about what's set out in this letter. Once my lords have read it through, I'll just make 3 or 4 very short points, if I may. Lord Mayor, proceed.
Yes.
I'm obliged, my Lord. So, my Lord, I'm not going to repeat anything that I've already said about transparency and so on. You've got that?
We have seen Lord Leggett's pointed out what was said on 1084, which does put a different complexion on the BAT offer. So I don't think you need to be too concerned on that.
I'm very grateful, my Lord. So, my Lord, just on this letter, so that, and my Lord Sales, put to me very fairly, if I may say so, well, and Lord Stevens, well, you know, how do you demonstrate that the courts below were wrong in the approach that they took, with of course the exception of the minority judgment? Well, in this letter, there is a succinct, and we hope comprehensive response to the complaints, and therefore that what was required on the part of the courts below was a consideration of these matters, and specifically a consideration of what's in this letter. Now, the fact of the letter is referred to en passant in the judgments of the majority and that of the first instance judge. But we say with respect, and my Lord Sales and the rest of the board will tell us whether we're right or not, that when we wrote this letter, we had very much Lord Sales' tripos question posed in Ayres Caesar, which essentially said, if you are to fall on that range of challenges in public law that can be knocked out on as far as the arguability of the claim is concerned, then you need to explain yourself, and that therefore that what the court would do, the court would consider this, and consider this carefully and say something about it. And what we say with respect is that that did not occur on the part of the majority. It did not occur on the part of the first instance judge. And my lords already have my points in relation to the role of Oliver Weinman and the whole of the commercial process and so on, and transparency. So that at this stage, where are we now? July 2022, of course it is open. Of course it is properly open to any applicant who has a viable case and who is disappointed to make a complaint about the fact that they came second in the race, because those are the facts. The facts are that they were told, you have got a very good bid, it's not as good as your competitor. That's the essence of what they were told, and that's what's contained in this letter, together with the detail. And in the face of that evidence alone, with great respect, i.e. the letter of the 31st of October 2019, and the board note alone, the case for discrimination, lack of transparency, unequal treatment, my Lord says, it does not matter with respect what label is put on it. As far as arguability is concerned, whether it's a constitutional claim, taken of course to Benny essay, or the public law claim, which of course overlap in this case. So says the respondent in its written case, and we agree that it simply can't go anywhere. And we would say with the greatest of respect that it would be wrong for the board to knock us out on the constitutional claim on the procedural point that you didn't file a motion or summons or something of that sort to say that the claim or some part of it could not proceed. When the argument down below, as is made evident from the notice of appeal that I drew your attention to when I opened my case, makes plain, it makes perfectly plain what we were arguing. And so we were advancing that we were in that very limited group of cases that we thought was anticipated by my Lord Sales and of course Lord Stevens, who's followed him in the case that I've already I've referred to. My lords, in the, I think it's 11 minutes that remain, I think that I do not have to say a great deal more orally as to amenability. I hope, that our case, our written case, sets it out. But my lords, would you permit me this summary? In this case, the idea that the central bank was not involved in and supervising a long, complex, expensive, internationally respectably managed sale process, the likes of which is unique in the region because of the scale of the portfolios. The idea that they were not involved in that process simply does not stand muster. It is contrary to the evidence and contrary to each and every one of the exhibits, very helpfully put forward by Mr. Ferguson. So that's what we say about amenability, to the extent that commercial transaction turns on amenability.
I don't follow that point. You're saying, of course, the bank was involved and was supervising this long process.
Yes.
Yes,
commercial process.
But ultimately, your argument is that it was a commercial process.
Yes.
But you accept at the same time that the bank as a public body was subject to public law duties.
That's point number two. I'm going to point number two, my Lord. So, my Lord, yes, you anticipate me.
No, but I'm just trying to see where your first point gets you. At the moment, it doesn't seem to get you very far.
Well, Lord, you're right. By itself, it could not get me very far. And so I come back to my answer that I gave to my Lord Stevens and an answer to my Lord Hodge. So given that it's a commercial process, and given that there are statutory obligations imposed on the bank, we say that something specific and provable by the evidence has to be adduced by the respondents in order to get over the hurdle of arguability or viability. And that hurdle, for the purpose of this discussion, whether it's...
Well, hang on. You're moving on to arguability.
Yes.
Arguability is a separate point from amenability. I mean, the question of amenability doesn't depend on the separate question of arguability. The question of amenability depends on the nature of the role being played by the public body.
Yes.
So are you saying, leaving aside arguability, are you saying because it is a commercial, it was as you characterise it, and as the bank characterises it, a commercial process, therefore it is not amenable in any circumstances to judicial review? Or are you saying it will be amenable to judicial review if the claimant go further and make out specific allegations?
Yes, that's precisely the point I was...
What are you saying?
Well, what I'm saying that amenability, the conclusion on amenability, prima facie, leads the board to be able to conclude not reviewable. However, is there something, leaving aside arguability for the time being, is there something specific, is there some allegation that is made that engages our public law obligations, that is not, how do I put this politely, that is not intimately connected with the commercial nature of the transaction? And my Lord, with great respect, the commercial nature of the transaction is not my characterization. It was accepted by the first instance judge and was accepted by the majority. So the courts below are at one as to the commercial nature of the transaction.
I thought you had accepted the proposition that despite its commercial nature, the bank had an obligation of rationality, good faith, equality of treatment.
Transparency, yes.
Transparency.
Yes, I do. And I'm not resigning from it, my Lord. I'm not resigning from that at all.
And therefore amenable to judicial review.
And therefore amenable to the judicial review, provided you have something to say along those lines. It's not simply with respect to a shopping list. There has to be something specific. And so that my Lord, allows me to go to arguability.
Yes.
Respectfully. And we say our case on arguability is whether it is a constitutional breach allegedly or a breach of our public law obligations challenged by way of judicial review, that there is no case no case made out on the claim. So we take our stand, rightly or wrongly, and the board will decide in due course, that when you look at what Mr. Ferguson says by way of evidence, as opposed to assertion, inference, and speculation, that there is no viable claim in public law made out against the Central Bank of Trinidad and Tobago. My Lord,
if you have an obligation of equality,
yes,
and you require there to be no conditions attached to a bid, and if it's arguable that a condition was attached to a bid, then isn't it unequal, unfair treatment, and not to afford the other party a similar opportunity? That's presupposing there is a condition.
Yes.
If there is a condition, then isn't it just unfair, unequal, not to allow the other party to put in a bid which is also conditional?
My Lord, presupposing that it's a condition of the nature that has been identified by the respondents in their written case, then although it is arguable, we say that in this particular case, the parties committed themselves to the following procedure, which is to say that they would decide how they structured their bid, and that they also decided and agreed that we could not, as it were, intervene to say to them, well, you've made a mistake. And that's why I drew my Lord's attention to those. I'm sorry, my Lord, go ahead.
I was on a slightly different. Assume for one moment that this was a breach of the requirement.
Yes.
That the bid's been unconditional.
Yes.
A breach by one of the bidders. Would it not therefore be unfair, unequal treatment, not to permit the other bidder to put in a conditional bid?
But Lord, the difficulty with giving them an opportunity to put in a further bid or a different.
Just looking at the question of unfairness, one can look at the practicalities of how you achieve that. But one way of doing it is just to reject the conditional bid. The other way is perhaps to engineer a situation where the other bidder has an opportunity to bid. But I'm just saying, if it was a conditional bid, isn't it just unfair to treat one person in one way and another person in another way?
Well, my Lord, I suppose my answer it has to be as follows. That firstly, in this case, to give the bidder who has not put in a conditional bid another opportunity is to create a different level of unfairness in relation to the other bidder. Because
I think if there's unfairness, it's already been done. I mean, that's the point, isn't it? But can I just take you up on something you were saying earlier about the interpretation of the conditional requirement? Because you were saying, and I accept that generally questions of interpretation are matters for the court. But I'm wondering whether that is the right test here in a tender document.
Yes.
Or whether it isn't required that it be sufficiently clear, the language, to ensure that all the people putting in bids will interpret it in the same way.
My Lord, I think.
And that if it's not clear in that way, and that it may be interpreted differently by different bidders, then that in itself may amount to inequality of treatment.
My Lord, if there were anything about the bid conditions that...
Well, I'm saying I'm focusing specifically on what's meant by you can't make your bid conditional.
Yes.
If that's ambiguous,
so
that's unfair and unequal.
And my Lord, I'm trying to respond. And so I say respectfully that there and this is partly an answer to my Lord Stevens. So, my Lord Stevens, I haven't forgotten that I haven't answered my Lord's question. I'm going to come to it in a second. My Lord Legate, my respectful answer to my Lord is as follows: that there was nothing ambiguous in the bid language on its face. That's number one. That any bidder who sought my Lord Stevens to put in a bid that linked the two is not seeking to act contrary to any express language in any document. What they are seeking to do is to act in the way that commercial entities are expected to act. In other words, to identify, business people use all kinds of language, synergies, combinations, amalgamations. That's essentially what happened here. But my Lord Stevens, if respectfully I am wrong as to the test, that's set out in the healthcare case and is applicable, and if the board concludes that it is arguably a conditional bid, then I think I'm bound to accept that that was not an act of fairness towards one of the bidders.
Okay. If the argument were to succeed, yeah.
Well, my Lord, bearing in mind the nature of the appeal,
yes,
I am pitching I'm nailing my colours to the mast, and I've said it already.
Yes.
My Lord, there is no ambiguity between my different as to what the test is.
Yes.
I accept that, and I accept that the threshold ordinarily is low. But in particular circumstances, the application of the low threshold, and is my respectful submission, is that the application of the low threshold in circumstances such as this.
No, the only point I was making is you were saying, in effect, that if the board concluded that there was arguably a conditional bid, then you were bound to accept it was unfair. But you were bound to accept it was
arguably unfair. Yes, my Lord. That's
unfair.
My Lord, yes. And I don't think that my Lord Stevens,
yes,
as penetrating a cross-examiner as he is, I don't think he was intending me to not accept that it was arguability.
We're not here to make a ruling on the judicial review itself. We are merely...
Absolutely. My Lord, I'm sorry. I didn't mean in that moment
of arguability.
Yes, my Lord, I didn't mean in that moment of levity to be anything other than respectful to the board. I do apologize, my Lord Stevens, and of course to my Lord Hodge. My Lord, on my estimation, I'm probably close to the end of play. My Lords, I'm told by Mr. Garcia, who is a specific watcher of the time, that I have 2 minutes left. My Lords, can I close by saying something about the constitutionality as far as arguability is concerned? Because, my Lords, my learned friends have spent a lot of time in their cases, in their written case. My Lord, my learned friend, in their written cases, have spent a lot of time really making kind of 2 points as far as constitutionality is concerned. The first is that their argument is that they were badly treated in relation to BAT. Their argument is not that they were badly treated in relation to CLICO. So my first submission is, on any basis, constitutionality, amenability, arguability, and the judicial review, is that even if you are against me on everything that I say, you ought to allow the appeal in relation to CLICO. You should allow the appeal in relation to CLICO because they don't have a case in relation to CLICO. So that's one. But number two, they spent a lot of time setting out very helpful dicta coming from the Caribbean Court of Justice that I'm bound to tell you the people of the Caribbean are delighted that the two apex courts are in conversation with each other. But as far as the substance of it is concerned, there was nothing in the last 20-odd pages of my learned friend's written case that seeks to advance, by way of evidence, the constitutional complaint against me, save and except the point that I was debating with my Lord Stevens a moment ago. So that these broad-ranging, open-ended allegations of lack of transparency and the like, which, even when they are made and refuted, can be very damaging to our institutions, we say, we ask the board to treat with them with some delicacy. My Lord, I suspect that I've now overrun the 2 minutes, subject to...
Well, we did start late because of my computer problems, so you haven't overrun.
No, my Lord, I'm deeply obliged. My Lord, I just, because I know that my learned friends, I understand both of them are going to be responding, I'd rather keep my 30-minute reply powder, as it were, dry. I'm sure my Lords would understand. So, my Lords, nothing that I've omitted to say, notwithstanding the very helpful questions coming from the board, as far as what's in my written case, do I abandon. So everything that I've written, we will learn. Can I just look to those who are with me to see if I've omitted anything? My Lords, unless I can be of some further... I'm sorry, my Lords.
Factual too, so I can understand on the affidavit. Mr. Benjamin, I've just been sort of puzzling over the central bank's affidavit.
Yes, my Lord.
I could invite your attention to page 1123. And this is the passage, paragraphs 57 to 60 in particular. It goes back to what I was asking you about in terms of a comparative exercise being done before the choice of preferred bidder.
Yes.
And my Lord Hodge pointed out paragraph 60
yes.
says something was done.
Yes.
But just looking back, paragraphs 58 and 59, which
yes.
seem to set out, insofar as we've got any detail
yes.
of the reasoning, that just seems to relate to the CLICO portfolio, not the BAT portfolio.
Yes. That's a fair observation, my Lord, yes.
So really, my first question is, am I right in thinking that actually the central bank affidavit doesn't give any account of why Sagicor was chosen as the preferred bidder in relation to the BAT portfolio?
My Lord, I would ask my Lord not to read the affidavit like that. I mean, my Lord, inevitably, once you have a large portfolio, then it attracts attention. But each of the, if I could put it this way, each of the generic observations about tips, about criteria, about each of the bidders is applicable to both portfolios. That would be the short answer. But if my Lord is asking me a pointed question as to whether or not...
I take up a long time on this,
no, my Lord, I'm sorry.
All the points made about the size of the portfolio...
Oh, yes, no, my Lord.
Hence the risk
yes.
seem very specific to CLICO, and you told us that CLICO is in fact a much bigger portfolio than the BAT.
Yes. So, my Lord, I'm sorry. I was simply...
So the factors would not be the same?
My Lord, can I just give you an example of what I mean by what I just said? So 59B is applicable to CLICO as well as BAT. 59C is applicable to CLICO as well as BAT. 59D is applicable to CLICO as well as BAT. 60.
But I was putting to you...
Yes,
these are factors relevant to CLICO. He seems to be explaining
my Lord,
why not
yes.
favour bidder for CLICO.
Yes.
Seem to address why not favour bidder for BAT.
My Lord, so can I just give you an example? And I'm very wary of taxing or wearing my Lord. If I contrast A with B, so we have the chapeau, it refers to CLICO. I note 2. 1, CLICO, so and so and so and so. But what follows in B, C, and D is not CLICO specific. That's really the point I was making, my Lord. Right. And if the governor wanted to be CLICO specific, he would have done so as he did in A. That's really my small point. And the same applies to paragraph 60. And the same applies to paragraph 67. Is really the point I was making. Right. And my Lord, insofar as you ask me a BAT-specific question, paragraph 68, it begins with a reference to BAT.
And I did want to ask you one quite small point on paragraph 68, E.
E, yes.
E for elephant. although Sagicor's bid price was lower than the applicant's, price was not the sole nor the highest weighted criterion. Now that is, am I right in understanding that that was the position in relation to the bid for the Clico
Yes.
portfolio,
but not
in relation to BAT?
Correct. And my lord, we are taxed on...
It's 68 little e.
Yes, I was confused about that because there seemed to be a contrast between the BAT document and what the governor was saying.
My lord, yes,
So are you saying that there somewhere we don't have it?
well, my lord,
we've only got a BAT.
You do have it, but sorry. So I was going to say...
Sorry, let me finish my question.
My lord, I apologise.
Are you saying that somewhere
yes.
we don't have it, but there is some document where some sort of weighting and comparative exercise was conducted in relation to Clico and the bid for the Clico portfolio, and that the weightings were different from those in respect of the BAT portfolio?
Yes, my lord, yes, that is the position.
I understand, thank you.
And I was simply going to say that because of the, perhaps this is the fair way of putting it, the preoccupation with Clico, in the other affidavits that were filed, which I haven't taken you to, in other words, there were some affidavits in the supplemental record. The error, because you can, there was, the impression that can be given was that price was not the dominant criterion in relation to both, and that's not the case at all. And my Lord Hodge, I think, has got that.
The impression given in paragraph 57,
yes,
and this is what confused me when
yes.
I saw the BAT board assessment, was that other factors were rated higher. I read that as meaning that there was a factor, both in relation to BAT and Clico, which was given a higher weighting
yes.
than price. You're representing to the board that in relation to Clico that was correct,
yes.
but in relation to BAT it is incorrect.
Correct. And the board note confirms that.
Yep.
Yeah, thank you, that's all.
Thank you very much.
My Lord, I'm just having my attention point to Can I just give you the page reference? And if I need to come back to it, I'm being told that there was something helpful to be said at electronic bundle page 1402.
1402.
Yes, paragraph 103. Yeah. And my Lord, if necessary, I'll come back to that. My Lord, I've taken up too much of my Lord's time. I'm grateful. Thank you, my Lords.
This is what are we looking at in 1402? That is that's your written case, is it?
Yeah, it simply says that.
What is the document? That it's paragraph 103.
Yes, it is your written case.
It's just my written case. In other words, I was just, I hope, either making a concession
so
or clarification.
you're just saying that in your case you're only making the claim in relation to Clico.
Yes.
That is correct.
Yes. My Lord, I hope that's helpful. My Lord Sayers, anything else for me?
Not for me.
My Lord Hodge.
Thank you very much, Mr. Benjamin. Well, the board will adjourn briefly to consider where we are on this matter. Thank you. Mr. Fitzgerald, Mr. Hussain, we do not require to hear from you. Thank you. In deciding that we do not need to hear from the respondents, the board wishes to make clear that what we are dealing with is simply an appeal on a permission to commence judicial review proceedings. The test to be applied is that the courts below are plainly wrong, and that is a very demanding test. In not calling on the respondent, the board is making no judgment whatsoever on the merits of the judicial review application. the board will take time and will produce a judgment in due course. I'm grateful to council for their efforts in this matter. Thank you.